A deposition is testimony which is taken under oath or sworn to by the person who's giving or offering the testimony. Depositions are usually taken by attorneys of witnesses that they anticipate will be used in trial. Often, depositions are taken of the plaintiff in either a civil case or a workers' compensation case. For the purposes of a deposition, the testimony will be very similar in both circumstances. They're just two different jurisdictions to which the testimony may be used. A deposition, as I said, is going to be sworn testimony. So at the beginning, questions are simply identifying the witness. So it will be a formal, yet somewhat informal line of questioning if you're the plaintiff. The goal of a deposition is for the other party to interview the plaintiff in the case. I represent plaintiffs, so my clients would be the person that's bringing the action. And if a deposition is taken, it's taken by a defense attorney. I sit there and I make sure that all the questions that are asked by the defense attorney are relevant, necessary, or require an objection. When doing a deposition, the key is you want to be truthful. You want to answer yes or no. There's no reason, if you are a plaintiff, to continue answering question with additional information other than what's being asked. I tell my clients, stick to the question that's being asked. Try to give a yes or no unless the question asks for something other than a yes or no. And then you want to be as detailed, but yet as minimal as possible, because you want to make sure that you are answering the question. However, there's no sense in providing information which may or may not be necessary. Only answer what's necessary during a deposition. And also, I advise my clients how I recommend that they answer the questions. And if you have an attorney, I recommend you speak with your attorney and obtain that same guidance as a witness. As I indicated, you want to be as truthful as possible. You want to answer the questions as best as you can based upon the question that's being asked of you. You're allowed to take a break if necessary during the deposition. And as I indicated, this is usually in a scenario that is not a courtroom. It's usually within the county of where the injury happened. The parties come together. Usually a deposition of the plaintiff is done at my office. It's scheduled amongst the parties. So it is within when you want to have it. There is the ability to have a deposition at a scheduled location within a scheduled period of time. However, as a professional courtesy, we don't normally see that. We usually see the parties coming together and making sure that everybody is appropriate in terms of making sure it's within the schedule that they have. And that way it makes it a more relaxed environment for the parties, because the ultimate goal of a deposition is to get discovery of information. It is in the discovery phase of litigation that you do a deposition. And so, as I indicated, each side will be asking and answering questions. The plaintiff's attorney, if it is a deposition of the plaintiff, will sit there, listen to the questions, make sure they're appropriate, as I said. If there is something objectionable, they will note it for the record. And then what will happen is the defense attorney will quit asking their questions, and they will pass it over to the plaintiff's attorney. If it's one of my clients, obviously me in that case. And then I have the opportunity to rehabilitate any answers that have been provided by the plaintiff by asking questions myself, which may get more information in order to detail something that I think may look a little bit of a gray area in a record. Following that, it goes back again to the defense counsel, and they're able to ask additional questions within that line of scope of questioning. Overall, depositions do not normally take longer than between 2 to 3 hours, but it depends on the nature of the case and the information that's being pursued.